In this lecture, we will discuss about liquidation supervision under IBC or Insolvency and Bankruptcy Code Regulations. So, experts on insolvency related matters have suggested reform measures to strengthen the insolvency and bankruptcy code, including clubbing of similar regulations, simpler supervision of insolvency professionals, and a more streamlined liquidation process. In response to a discussion paper by the Insolvency and Bankruptcy Board of India, seeking comments and feedback on regulation and compliance. The Insolvency Bankruptcy Board of India has floated a discussion paper seeking comments from stakeholders and experts on all regulations notified under the Insolvency Bankruptcy Code with an aim to simplify is and reduce cost of compliance. In total, the boards had views on 13 regulations, including the Insolvency and Bankruptcy Board of India's Insolvency Professional Agencies Regulation 2016, then the Insolvency Professional Regulations of 2016, and also the Liquidation Process Regulations of 2016, and the Insolvency and Bankruptcy Board of India's Informal Utilities Regulations 2017, among others. So, the experts said although Insolvency and Bankruptcy Board of India over the years has ensured the Insolvency Bankruptcy Court's regulatory framework is aligned with constantly evolving jurisprudence, the presence of multiple regulations and regulatory perceptions is a hindrance to resolution process impacting time-bound closures. So the Insolvency Bankruptcy Code mandates the corporate insolvency resolution process. So, the corporate insolvency resolution process should include within 330 days. However, the process takes over 700 days to complete. In the financial year 2024 and 25, the average time taken by the corporate insolvency resolution process to complete was 716 days, up from 654 days in the last financial year, and that is financial year 23 and 24. So now we will discuss about the clubbing regulations, and as such experts have backed the need for simplification and consolidation of regulations which lead to faster completion of the corporate insolvency resolution process, and suggest that the Insolvency and Bankruptcy Board of India should club all regulations pertaining to administrative matters such as insolvency and Bankruptcy Board of India's Inspection and Investigation Regulation of 2017 and Insolvency and Bankruptcy Board of India's mechanism for issuing regulations of 2018, etc. under this head. So, there are certain regulations that we deal with similar concepts, topics, and can be clubbed together under one set of regulations for streamlining the process. So, these may include Insolvency and Bankruptcy Board of India's Insolvency Resolution Process for personal guarantors to corporate debtors regulation of 2019 and the Insolvency and Bankruptcy Board of India's bankruptcy process for personal guarantors to corporate debtors regulation of 2019 and also the Insolvency Professional Agencies Regulations of 2016 and also the Liquidation Process Regulation of 2016 and also the Insolvency Bankruptcy Board of India's Voluntary Liquidation Process Regulations of 2017, the Prefect Insolvency Resolution Process of the rules, the Annual Report rules, and also the Registered Valuers rules may be subsumed within the corporate insolvency resolution process. Other experts suggest that the new Insolvency Bankruptcy Code Amendment Bill likely to be tabled during the monsoon session of the budget session should remove the requirements of the National Company Law Tribunal approval for extension of time limits for the corporate insolvency resolution process to 330 days instead of approval should be enough in this regard. Insolvency professionals and in that regarding the very liquidation process. So, in connection to insolvency professionals, some said the dual regulation mechanisms of insolvency professionals should be done away with. Currently, the functioning of insolvency professionals is regulated and supervised by both the Insolvency Bankruptcy Board of India and the Insolvency Professional Agencies resulting in increased cost of compliance. So, considering that all insolvency professionals are required to mandatorily be enrolled with an Insolvency Professional Agency in terms of Section 206 of the Insolvency Bankruptcy Code, one key change could be that the task of regulating the insolvency professionals could be delegated to the insolvency professional agencies to the extent possible, and the Insolvency and Bankruptcy Board of India can exercise indirect control through their control over why the bylaws of the insolvency professional agencies as per the provisions of Section 205 of the Insolvency and Bankruptcy Codes of 2016. So now we would like to discuss about the simplifying liquidation process to streamline the liquidation process under insolvency, bankruptcy code. Experts recommended including an affirmative provision in the regulation clarifying that the stakeholders consultation committee has the final authority on the sale of a corporate debtor as a going concern. This would eliminate the need for liquidators to seek national company law tribunals permission unless specific reliefs and concessions are required, thereby reducing unnecessary filings and expediting the very process. So the requirement to file progress reports with the National Company Law Tribunals under Regulation 15 of the Liquidation Regulations. Resolution should be eliminated. Instead, progress reports should be uploaded directly on the Insolvency Bankruptcy Board of India's portal in a standardized format. This change will reduce delays, cut unnecessary legal costs, and enhance overall efficiency of the insolvency bankruptcy code processes. So, this is all about the liquidation and supervision procedures as suggested by experts which falls under insolvency, bankruptcy, code regulations, and in that connection we have discussed insolvency and bankruptcy Board of India and those regulations relating to insolvency professional agencies regulations 2016, insolvency professional regulations 2016, liquidation process regulation 2016, information utilities regulation 2017, and corporate insolvency resolution process. In regards to clubbing of regulations and in that connection, we have discussed inspection and investigation regulations of 2017, the mechanisms for issuing regulations of 2018 insolvency resolution process for personal guarantors to corporate debtors regulation 2019 bankruptcy process for personal guarantors to corporate debtors regulation 2019 voluntary liquidation process regulations 2017 and the prepackaged insolvency resolution process rules such as annual report rules, registered valuer rules, insolvency, professional agencies, and the very provisions as provided under Section 206 and Section 205 of the Insolvency Bankruptcy Code. And finally, we have discussed about the simplification of liquidation process as it held stakeholders consultation committee and in pertaining national company law tribunals forward and also the regulation 15 of the liquidation regulations. So, in our next upcoming lecture, we will discuss about the personal guarantors to corporate debtors.